your H-1B wasn't selected. Your employer checked the My USCIS portal and the status still says submitted. No selection notice, no next steps, just silence. I get it. That feels like a door slamming shut. Here's what I need you to understand right now. That door was never the only one. The H-1B lottery is only one pathway. It is not the pathway. And the professionals who build successful immigration strategies, the ones who actually get green cards, treat the lottery as one of many in a larger toolbox. My name is Diego Bustillos. I am founding partner at BBA Immigration in Houston, and I've spent years helping STEM professionals in energy, healthcare, and technology find the right visa strategy, especially when the H-1B doesn't work out. Today, I'm going to walk you through 5 concrete alternatives that are real pathway. We file them every week, and at least one of them probably fits your situation better than you think. So let me give you quick context. The fiscal year 2027 H-1B lottery closed on March 19th. Immigration Services started posting selection notices on March 27th. This year introduced the first ever wage-weighted lottery. Higher salary positions received more entries in the draw. Level 4 positions got 4 chances. Level 1 positions got 1. The overall selection rate sits somewhere between 34 and 42%. That means the majority of registrants did not get selected. So if you are in the majority, you are in a large and talented group of people, and you have options. Let's talk about these options. Number 1, the O-1A visa. The O-1A visa exists for individuals who demonstrate extraordinary ability in science, business, education, or athletics. It requires no lottery and there is no annual cap. Your employer or a U.S. agent can file the petition and Immigration Services can process it in premium processing within 15 business days. Now, I know what you're thinking. Extraordinary ability sounds like Nobel Prize territory. It isn't. The O-1A requires you to meet 3 of 8 evidentiary criteria. These include things like published articles, awards, some university awards can count, original contributions of major significance, a high salary in comparison to others in your field, or membership in associations that require outstanding achievement. Of course, some people confuse it with the EB-1A category, and generally speaking, requirements are similar, but the standard for an EB-1A is much higher because that one will give you a green card. So if you are a senior engineer, a published researcher, a data scientist with patents pending or filed, a healthcare professional with documented innovations, you may already qualify. The evidence standard for O-1As is lower than the EB-1A green card. It is a temporary visa, yes, but it puts you inside the United States working legally with no cap and no lottery. And it gives you the time you need to build toward permanent residence. 2, the EB-2 National Interest Waiver. This is the pathway I want every STEM professional to truly understand. This is not about submitting a business plan. This is not just about your degree. This has a deeper meaning and requires precision and strategy. So the EB-2 National Interest Waiver category lets you self-petition for a green card. No employer or agent sponsorship required. No labor certification, no perm process. You file the petition yourself based on the national importance of your proposed endeavor in the United States. So the key word there is endeavor. A lot of people confuse the word endeavor's meaning. This is both a noun and a verb. So even USCIS officers give it a meaning sometimes that is not the real meaning of the word. An endeavor is a serious, determined effort directed towards a goal. So Immigration Services evaluates NIW petitions under a 3-part test from a case called Matter of Danisar. We have a video explaining the history of NIWs. If you'd like to take a look at it, click on the video. First, you must show that your proposed endeavor has substantial merit and national importance. That is just one requirement, but in practice, it's 2. Second, you need to prove that you are well positioned to advance that endeavor, and third, that waiving the labor certification would benefit the United States even if there are other qualified American workers. NIW does not require lottery, does not require a specific employer, although an employer might help, and here's something most people miss. You can file the I-140 right now and lock in a priority date, even while you explore other status options. And right now, you could even file for adjustment of status if that fits your strategy. Consult with an attorney to see if it does. One important note for professionals born in India, the NIW does not create a separate or faster queue. You still have to follow the EB2 India line, which has moved a lot in recent months, but you can't score a goal unless you kick the ball. So the NIW can give you independence from any single employer, and that freedom is worth something. 3, the L1 intra-company transferee. So if you currently work for a multinational company, or if you have worked for one outside the United States in the last 3 years, the L1 visa may be your fastest option. The L1 allows said companies to transfer employees from a foreign office to a U.S. office in a managerial, executive, or specialized knowledge capacity. So, for example, if you worked for a multinational company, came here, did a master's, it hasn't been over 3 years since you worked for that company, and that company has a headquarters in the United States, that company could potentially sponsor you for an L1 visa. There's no lottery. There is no annual cap for individual L1 petitions. And the L1A category for managers and executives can lead directly to an EB1C green card, one of the fastest employment-based green card categories available. So if your company has offices in Houston, New York, San Francisco, and also in Bogota, London, or Mumbai, talk to your HR team today. This pathway exists precisely for situations like yours. 4, cap exempt H-1B positions. Now here's something most people don't realize. The H-1B lottery only applies to cap subject employers. Certain organizations can file the H-1B petitions year-round. No lottery, no cap. These include universities, nonprofit, research organizations, and government research entities. So if you work in healthcare, research, or academia, or if you're willing to consider a position at a university-affiliated hospital, a federally funded research lab, or a qualifying nonprofit, you can still get an H-1B this year. The cap-exempt H-1B uses the same form. The same specialty occupation standards apply. The only difference? No lottery. So I've seen petroleum engineers, biomedical researchers, and data scientists who used to work for major companies pivot to cap-exempt positions in research with an approved H-1B. 5, the E2 Treaty Investor Visa. The last pathway is for the entrepreneurs in the room. The E2 Treaty Investor Visa allows nationals of certain countries to start or invest in a U.S. business. This option, we've also seen it used by spouses. So let's say you have two individuals who are Argentinian nationals. Argentina has a treaty, and you've got both of them in the United States. One of them came in on an F1 visa and the other one as a dependent. Meanwhile, they found a business they want to invest in, so one spouse invests in the business, gets that E2 visa, and the other spouse can go work with a work permit based on that E2 wherever they want. Here, there's no lottery and there's no annual cap, and the visa can be renewed indefinitely as long as the business operates. So the E2 requires a substantial investment in a real operating business. USCIS and the consulates want to see that you are directing and developing the enterprise, that the business is more than marginal, and that you have committed capital at risk. For example, buying land is not capital at risk. So countries like Colombia, Mexico, France, Germany, South Korea, Japan, and dozens of others can be a powerful option. And we've helped entrepreneurs launch businesses in industries from paddle sports to energy services to technology consulting, all on E2 visas. So if you have a viable business idea and the capital to back it, this pathway deserves serious consideration. Of course, the question is always, what is substantial? And people often think that the investment has to be hundreds of thousands of dollars, but the investment has to be the amount generally required to push that type of business forward. So the amount to start an airline will not be the same that you need to start a technology consulting firm. So here is my challenge to you. Don't sit with this news for weeks. Don't wait until your OPT or current status is about to expire. Professionals who navigate this successfully are the ones who act early and act strategically. Step 1, identify which one of these 5 pathways fits your background. Step 2, gather your evidence. Send us your resume, publications, potential letters of recommendation, a business plan, whatever applies. Step 3, consult with an immigration attorney who understands employment and investment-based petitions and who can evaluate your specific situation. At BBA Immigration, we work with STEM professionals every single day. Engineers, researchers, physicians, technology leaders. We help them build immigration strategies that do not depend on a lottery draw. If you want a case evaluation, the link is in the description below. The H-1B lottery did not select you. That does not define your options. It just means your path forward looks a little different. And honestly, for many of you, it may look even better. I'm Diego Bustillos with BBA Immigration. Subscribe to this channel for more immigration strategy content, and I will see you in the next one.